Hello, and thank you for joining us today. My name is David Gabor, and I am a member of the Human Resources and Employment Law team at the Wagner Law Group. I'm joined by my terrific colleagues, Catherine Brustowicz, Johanna Matloff, and Denise Chicoine. One bit of housekeeping that I want to share with you is if you have any difficulty during the program today, we have an email that you can email to and get prompt attention. It's webinars with an S at the end at wagnerlawgroup.com. Webinars at wagnerlawgroup.com. So let's talk about the agenda and goals for the program. As most of you are aware, many people have extremely strong political opinions about the last election and the steps taken by the new administration to enhance their goals. Nothing that we share with you during the webinar today is intended to project the political beliefs of any of us or the Wagner Law Group. We're just talking about the issues that are impacting employers. And also, as is true with our other webinars, we're not providing you with legal opinions. Please don't rely on what we share with you as legal guidance regarding steps that you can take. What we are doing is we're identifying issues and talking about those issues. So we're going to talk about the executive orders impacting the DEI, D&I, deregulation, some of the impact on staffing at the EEOC, Equal Employment Opportunity Commission, and the National Labor Relations Board. There has been executive orders on anti-Semitism and anti-Christianity we're going to talk about. We're also going to briefly touch on immigration. That's the first part of the program. The next part is there are questions that have been presented to us, and we're going to talk about several of those questions as we go through the program today. So let's talk about, Catherine, how about DEI? Do you want to talk about that, please?
Sure. Thank you, David, and thank you for that excellent introduction and the necessary disclaimers. So, moving on to the next slide here. There we go. So the executive orders that I'm going to be focusing on are titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, and Ending Radical and Wasteful Government DEI Programs and Preferencing. The primary focus of these particular executive orders is on DEI initiatives and race and sex-based affirmative action. Denise is going to talk shortly about the impact on disability and accessibility as well. Now, these executive orders have introduced some significant changes for federal contractors, private employers, grant recipients, and educational institutions. And they have a profound effect on and largely entirely repeal diversity, equity, and inclusion initiatives, as well as diversity, equity, inclusion, and accessibility initiatives. The executive orders require the federal government and federal contractors to terminate all, quote, discriminatory, end quote, programs, explicitly including DEI and DEIA mandates, policies, programs, preferences, as well as activities under whatever name they appear. So that's a very important distinction, and we'll talk more about it later. But just keep in mind that it's not enough to keep a DEI or DEIA program in place and simply rename it. These executive orders also require all federal agencies to encourage private sector employers to terminate their discriminatory practices, including race and sex-based preferences and DEI mandates and activities. Keep in mind that the executive orders are very broad. They do not define what exactly an illegal or discriminatory program is, and there's no guidance from the federal government yet. So the full scope of the order's prohibitions are still murky at best, and we still don't know what practices would be consistent with the orders. We do know that affirmative action requirements for federal contractors have been eliminated. This means that federal contractors should not be preparing affirmative action plans regarding women and minorities. But don't forget that pay equity is still the law under existing civil rights laws. Many states have also enacted pay transparency laws to combat the historic pay gaps between men and women, and those state laws are not affected by these recent executive orders. DEI and DEIA offices and initiatives have been terminated across the federal sector, and a heightened scrutiny over illegal DEI programs in the private sector has now been established. The executive orders also direct federal agencies to investigate private sector organizations for potential civil rights law violations. One part of the executive orders rescinded the 1965 executive order, which had rolled civil rights priorities into the federal contracting process. That order created the requirement that all government contracts and job postings included a statement that the contractor would not discriminate against any employee or applicant for employment because of race, creed, color, or national origin. Those statements now must be removed from federal job postings and contracts. The executive orders include a requirement that going forward, federal contractors will need to file a certification that they are in compliance with the orders. I think Joanna is going to address who is required to comply with these executive orders in more detail in just a little while. Now, we'll talk a bit later about what prudent next steps for employers would be, but it goes without saying that this is a time when legal counsel is going to be very helpful, particularly in aiding employers in reviewing all of their human resources practices to identify any policies or procedures that may be perceived as including illegal discrimination or preferences under federal law. So that includes reviewing practices related to hiring, promoting, and even mentoring your workforce. I'm going to stop at this high-level overview for now. We've received quite a few distinct questions from the group already, so I want to ensure that we have time to address all those later in the program. With that, I would like to turn it over to you, Denise.
Thanks, Catherine. So with regard to disability, this is implicated by the executive order that Catherine just described. The primary focus of the executive order is on race-based and sex-based affirmative action, but it references diversity, equity, inclusion, and accessibility. So disability inclusion efforts may now be under scrutiny as well. Programs promoting disability inclusion, disability non-discrimination, and disability accessibility are already required under federal law and have been for decades under the Rehabilitation Act. Section 501 of the Rehabilitation Act forbids discrimination by federal agencies against people with disabilities. It also requires reasonable accommodation, and it requires federal agencies to implement affirmative action for employment of people with disabilities. Specifically, federal agencies are required under the Rehabilitation Act to aim for a percentage of their workforce of people with disabilities, specifically 12% of the workforce, and 2% of the workforce is to be people with targeted disabilities. So without getting too down into the weeds on that point, the question is whether the executive order conflicts with the mandates of the pre-existing Rehabilitation Act. Also under the Rehabilitation Act, there is something called accessible technology for all. This is Section 508. Digital accessibility is protected and mandates that federal websites and any type of software utilized by federal contractors and all federal electronic materials must meet the Web Content Accessibility Guidelines. It's unclear at this moment, 3 weeks into this order having been issued, whether the directive to close federal DEIA offices also targets Section 508 offices, meaning whether this will have an impact on the question of accessibility of technology, in addition to the points I mentioned about the workforce percentages, and just even generally accommodation. So that remains to be seen, but it is a point, as I said, that is raised by the language itself and the implementing memorandum of the Attorney General, which we will touch on later. So let me now turn it over to Johanna to talk about deregulation.
Thank you, Denise. So I'm going to talk about the executive orders on deregulation and the changes at the EEOC and National Labor Relations Board. So the executive order regarding deregulation provides sort of an insight into its purpose, which is, according to the order, over-regulation is an impediment to entrepreneurship, small businesses, consumer choice, innovation, and it infringes on liberties, contributes to high cost of living, and drives energy prices up. That is the motivation of the order. And as a result, the order provides that for every rule, regulation, or guidance promulgated by a federal agency, the agency must identify at least 10 existing rules, regulations, or guidances to be repealed. And during Trump's first term, he imposed a similar order and achieved a 2-for-1 goal of eliminating regulations. And in the prior administration, for every regulation that was promulgated, 2 regulations had to be revoked. Obviously, this is significant and will impact the regulatory ability of federal agencies during the next 4 years. The other point was that the order orders that regulatory costs associated with these efforts will be reduced to significantly less than 0, which also indicates the direction that the administration is moving in with regard to regulation. As for additional changes that the administration has imposed on the EEOC and NLRB, President Trump has appointed Commissioner Andrea Lucas as acting chair of the EEOC and has removed previous commissioners Charlotte Burrows and Jocelyn Samuels. As a result of these changes, there is no longer a quorum at the EEOC. So under Title VII, the EEOC's leadership panel is comprised of 5 commissioners. Right now, there are only 3 commissioners. Right now, I'm sorry, there are only 2 commissioners. And in order to have a quorum, 3 commissioners are required. So as of January 28, 2025, the commission only has 2 commissioners and no quorum. The EEOC is still open for business and does not impact the processing, investigation, resolution of charges of discrimination. It does not impact the EEOC's ability to issue right to sue letters. The EEOC will still be able to file certain lawsuits, approve contracts, issue decisions on petitions to revoke or modify or enforce subpoenas, and other ministerial changes to regulations that are required by statute. However, the EEOC will not be able to vote on rulemaking, issue new policies, or rescind guidance documents without a quorum. And the focus of the EEOC is likely going to be on merit-based decisions and a closer examination of DEI initiatives, as was previously discussed by Catherine. At the NLRB, after 2 discharged replacements, President Trump has now appointed William B. Cowan as the acting general counsel of the NLRB. It's unclear if he will be formally appointed, but his appointment must be approved and confirmed by the Senate. President Trump also removed member Gwen Wilcox. And as a result of that removal, the NLRB no longer has a quorum. So there are only 2 sitting members, Republican appointee Marvin Kaplan, who's the chair, and the Democratic appointee David Prouty is also a member. Wilcox has legally challenged her removal, so we'll see how that pans out and affects affects this issue going forward. Field offices can still hear unfair labor practice cases, but without a quorum, the board is unable to hear any challenges to those decisions. So now I'm going to hand this back over to Denise to talk about the executive order on anti-Semitism.
Yes, thank you, Johanna. January 29th, the White House issued an order entitled Additional Measures to Combat Anti-Semitism, and it references an order from 2019 and has new provisions in it. Essentially, under this executive order, every federal agency is charged with identifying, and here's the language, quote, all civil and criminal authorities or actions within the jurisdiction of that agency, beyond those already implemented, that might be used to curb or combat anti-Semitism, end quote. There is also a directive to the Attorney General and to federal agencies to inventory all complaints and pending cases filed since October of 2023 involving any institution of higher education. Finally, in this executive order, there is a statement that directly implicates immigration and creates what I believe is an additional ground for deportation. Section 3E of this executive order states that the Secretary of State, the Secretary of Education, and the Secretary of Homeland Security, in consultation with each other, shall include in their reports certain recommendations for familiarizing institutions of higher education with the grounds, quote, for inadmissibility, and it references the National Immigration Act, grounds for inadmissibility such that these institutions must monitor for and report activities by alien students and alien staff relevant to those grounds, end quote. Meaning that if there is a report or a question about students or staff who are not U.S. citizens who are engaging in conduct that is defined under this executive order as anti-Semitic, that this must be reported to the federal agencies and would be grounds to begin a removal case. So I am not an immigration attorney, but this is just issue spotting to state that these orders do have broad implications, particularly this one for any college or university. And that segues actually into further comments of immigration by David Gabor.
Thank you, Denise. Thank you very much. And we all know that immigration was a hot topic during the election cycle, and it's a priority in the Trump administration. So why does this impact employers? Some industries, we all know, are more likely than others to employ immigrants, some even with people who are either illegal or undocumented. But really, all major employers do have some immigrants working there. The reason why this is important is the United States Citizenship and Immigration Service has a requirement regarding what's called the Form I-9, which is a requirement for every employee. It must be completed properly and maintained in an appropriate place in the company. And over the past many years that we've practiced law, we've been called upon by companies to audit their Form I-9s. And when we've done those audits, which are not a federal government's audit, it's our private audit, we have found discrepancies, we found issues. Mistakes were made when some Form I-9s were completed. They may not be signed or dated, or they lack necessary documentation. This is something that may happen over the next couple of years, where an increasing number of employers will get audited by the federal government. And the best thing to do is make sure now, before that happens, that you have your ducks in a row. So we suggest that you either independently or with a lawyer or a consultant do an internal audit to make sure your Form I-9s are up to snuff. And let's shift gears now. And I did mention that we've got questions to answer. And hey, Catherine, how about you take the first question?
Sounds good. Thank you, David. So the first question that was posed is, any word on whether or when the DOL will get rid of liquidated damages, as was the case in the first administration? It's a good question. I have not seen anything new on this since mid-2021, and that was when the DOL had made clear that it would not be getting rid of liquidated damages and instead returned to its policy of seeking liquidated damages in pre-litigation investigations and in settlements of wage and hour claims. So in other words, the DOL had effectively reversed Trump's first term's practice of refraining from doing so. That being said, I would not be surprised if this is on the administration's to-do list. So I would say that this is definitely an issue, not only that we will continue to monitor, but that would be prudent for you to monitor as well. But at the moment, I have not heard or read about any updates on that front. The next question that I wanted to address is any word on whether the Biden administration changes to the civil monetary penalty determination process contained in DOL FAB 2023-4 will be eliminated or revised? Similar to the last question, I have not come across any recent updates on the elimination of the civil monetary penalty determination process. I would think that rather than the process being eliminated in its entirety, it's more likely to be revised. But again, I've not heard much chatter about this particular issue, so it is it's going to be best practice to keep your ears and eyes open for potential changes. And again, our law firm will continue to monitor this development as well. Denise, we have another question that I believe you would like to address.
Yes, thanks, Catherine. This is what happens if an executive order is at odds with a statute. We have already seen in the past 10 days a raft of litigation filed in various district courts, federal district courts, seeking injunctive relief. So that is one point where the litigants are challenging the standing or the authority or whether there is a conflict. Specifically in regard to the DEI that we're discussing here, and I had mentioned earlier, the Rehabilitation Act creates certain protections for individuals with disabilities. If the claim were raised that an executive order conflicts with, for example, the Rehabilitation Act, these requirements that are attempting to be altered by the executive order have the force of being enacted by Congress through statute and regulations. So this means that pre-existing requirements and pre-existing statutory obligations cannot simply be changed through an executive order. In order for the administration to implement changes to pre-existing statutory requirements, Congress will have to act to eliminate things such as non-discrimination and affirmative action requirements. And the government will need to undergo a rulemaking process and publish a new proposed rule for public notice and comment requesting to change hiring goals. Other aspects of this, though, if the administration simply refuses to implement the protections any longer, then these protections may be at risk. Protections such as accommodations for individuals with disabilities or hiring goals. And without the government implementing these pre-existing obligations, it'll place the onus on private individuals and organizations to enforce the law. And that really segues to a question for David. If accessibility is no longer required, do employers have to continue to make accommodations to individuals with disabilities?
Thank you, Denise. And that's a question we've been asked many times in the last couple of weeks. And I'm going to focus on private employers. And the two statutes that I'm focusing on are the Pregnant Workers Fairness Act and the Americans with Disabilities Act. Right now, these are the statutes, and this is a law that employers are expected to follow. We've seen court cases that talk about what protections are. We see what the statutes say in writing. And while we are in a much more employer-friendly environment, we do believe that the law is a law, and it's the employer's obligation to follow the existing laws. And the ADA says, if a person has got a disability that's covered by the law, they have a right to engage in the interactive process to determine whether or not a reasonable accommodation can be secured so that they can perform the essential functions of the job. Under the Pregnant Workers Fairness Act, it also talks about a disability to enable the employee to continue to perform the essential functions of their job. The caveat under the Pregnant Workers Fairness Act is if there's a choice between the employee being out on leave or having the accommodation, the employer must offer the accommodation. The public policy at the time the law was enacted was to keep people working as much as possible. So, I think that at this time, and again, we're reading tea leaves, not knowing what's going to happen, at the legislative level at some point down the road, the best thing to do is to go through the interactive process and see if you can find that accommodation. And one other thing, please, please, please document the process. We've had a couple of times recently where people failed to document the process, and it's created a bit of a nightmare for some employers. Catherine, I guess it's your turn.
Thanks, David. And great point about documentation. That's something that cannot be overstated, frankly. So thank you for that excellent reminder. The next question that we received is, do employers still have to prepare EEO-1 statements and affirmative action plans? The EEO-1 reporting obligations do continue under Title VII for private employers. Remember that data collection requirements are authorized through the end of 2026. And while the EEOC acting chair may want to eventually end that reporting requirement, it's important to recall, as Joanna had actually mentioned earlier, that the EEOC does not currently have a quorum. And so that means that the EEOC cannot currently issue new policies or rescind guidance documents. So without the quorum, the EEOC cannot begin the regular process of changing that existing authorization. I have heard that some people are questioning whether or not federal contractors need to abide by the reporting obligation, but the EEOC itself has not yet stated it as such. So I would say to assume you will still need to prepare the EEO-1 Component 1 report unless or until you are told otherwise. And the part of this question about affirmative action plans has a different answer. As a result of the executive order that we were discussing earlier, the one titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, government contractors are generally no longer required to maintain affirmative action programs. And in fact, they should not be preparing affirmative action plans for women or minorities. But remember what Denise had mentioned, the requirements for affirmative action plans for people with disabilities are still in effect. And it's very important to recall that employers still need to abide by Title VII and anti-discrimination laws. Joanna, would you like to address the next question that we have?
Yes, thank you, Catherine. So the next question we have is, who must comply with the executive orders prohibiting illegal DEI initiatives? So there are some clear categories here. Obviously, the federal government must comply, and federal contractors. So anybody contracting with the federal government, including suppliers and vendors, must also comply. Other organizations also have to comply if they receive federal grants, such as certain teaching hospitals, universities, or other nonprofits. Basically, any organization that receives federal funding must comply. It's also encouraged that the private sector comply, although this does implicate First Amendment rights. And it does raise some questions, which we'll touch on shortly, about what it means to have a quote unquote criminal DEI policy. And also keep in mind that with the EEOC's heightened focus now on merit-based opportunities, the EEOC is going to be perhaps looking at this more closely in the private sector, as the EEOC has authority over all employers with 15 or more employees and 20 or more for age-related issues. So David, you're going to address the next question.
Yes, thank you. The Department of Justice issued a memorandum on February 5th, 2025, and the question being, who is a likely target? Well, according to the DOJ's memorandum, it's focusing really on large companies that have a DEI program. In some of the writing, they're talking about, large companies that have got hundreds of millions of dollars in business that they do, foundations with assets at $500 million, higher education with endowments over $1 billion. But what the DOJ wrote, and this is really very instructive, is they indicate they are enforcing the anti-discrimination statutes. And they quoted a Supreme Court decision in the Students for Fair Admissions versus Harvard, where it was written, quote, making clear that policies relating to diversity, equity, and inclusion, DEI, and diversity, equity, inclusion, and accessibility, DEIA, violate the text and spirit of our long-standing federal civil rights laws and undermine our national unity. The memorandum goes on to say, to fulfill the nation's promise of equality for all Americans, the Department of Justice's Civil Rights Division will investigate, eliminate, and penalize illegal DEI and DEIA preferences, mandates, policies, programs, and activities in the private sector and in educational institutions that receive federal funds. So the focus is pretty much any employer, and I think we can go back to the 15 or more employees, that we were talking about earlier. Really, it's any employer that's involved in some form of a DEI initiative, DEIA initiative, or training, or anything along those lines. Let me go a little bit further on this. It's not just the federal government, there's a shift also in the private, in the states. A coalition of attorney generals from 10 states wrote to 6 major financial institutions, this is within the last couple of days, about their race and sex-based quotas and any investment decisions that were in furtherance of political agendas. There's indicating that may violate federal and state law. That's a letter that these 10 attorney generals wrote. And This is hot off the presses from February 11, 2025. The Missouri Attorney General filed a suit against Starbucks, our beloved coffee ambassador, accusing the company of race and sex-based discrimination, favoring women and people of color. The Attorney General alleged that Starbucks set goals for representation of women and people of color. Quote, whether described as benign discrimination or affirmative action, the racial quota is nonetheless to create a cast or a two-edged sword that must demean one in order to prefer another. Essentially, you're going to demean white men to a preference for women or people of color. And the Attorney General went on to assert that this practice has led to higher prices and longer waits for people to be served their coffee. And with that, Denise, I'm going to pass it back to you.
Thank you, David. So I think you've addressed pretty well a lot of what the enforcement is going to look like, but we have been asked specifically, what are the consequences of non-compliance with the executive orders regarding DEI? And the obvious point that David has explained here is the loss of government funding. And this is such a broad net that the government is able to cast, as we saw from when the funding was suspended summarily and uniformly in the first week of the administration. It touches upon not just, national parks and the environmental agency, it's the NIH, it's federal research grants, it's all the research funding that goes to every institution of higher education that has these types of programs in place. And government funding extends to contracts with companies, any of the defense industry, any types of, really, it's such a broad, it's so immersed and intertangled now in our economy that I think this is a very potent threat that individual companies, even if they feel that they're in the private sector, if they are engaging in illegal DEI or criminal DEI, that they will face a loss of funding. The potential enforcement actions are both civil and, as we heard David explain from the Department of Justice memorandum, also potentially criminal penalties. So it's a confusing framework because, as we also pointed out, these pre-existing statutes that have been around for decades, Title VII, the Americans with Disabilities Act, and the Age Discrimination and Employment Act, to name just a few, the Pregnancy Discrimination Act also, these are still in effect. But now many employers are going to be in the crosshairs of how to address their obligations to the workforce, which leads to a question to Johanna. What is the difference between illegal DEI policies and criminal DEI policies?
So thank you, Denise. That's a great question. So an illegal DEI policy, at least in accordance with the executive order that the Trump administration issued, is any policy or practice that gives preference to someone because of their race or their sex. It also could include the rebranding of an existing initiative. If in operation, it's still a DEI initiative that gives preference to somebody in the context of their employment because of their race or sex or other protected class category. And as we've been discussing, there is some risk to employers that there will be civil enforcement of this new order, which would be under Title VII and perhaps Title VI, governing the receipt of federal funds. But I think what's missed a little bit is there's been references to criminal DEI policies. And it's, when you think about DEI and criminal, it's sort of a hard, what does that mean exactly? And so federal contractors in particular, I think, are going to face some greater exposure, potentially criminal exposure, because now they will be required to certify and or agree in their contracts that they have complied with all federal anti-discrimination laws and do not operate DEI programs that now violate the executive order. So federal contractors have to be very careful when they sign these agreements and certifications that they are in fact true, because if there are perceived to be misrepresentations or inaccurate statements, federal contractors could be subject to mail or wire fraud charges for failing to comply. There was a prior decision, Cousisis versus the United States, in which contractors who lied about complying with a requirement to use subcontractors who were quote unquote disadvantaged business enterprises had committed wire fraud and had submitted false statements to the federal government. And one contractor had been sentenced to 70 months in prison, and another was forced to forfeit profits and pay a $500,000 fine. So taking that precedent and applying it here, you can see how potentially easy it could be to expose yourself to these types of criminal penalties. Another potential avenue for criminal liability would be the False Claims Act. And the False Claims Act provides for treble damages, and it also provides opportunities for private litigants and internal whistleblowers to recover a share of the proceeds that are recovered by the federal government, known as qui tam incentives. So again, depending on the federal contractor and your workforce, you need to be careful, as this could become a runaway train in some respects, where if there's incentive for whistleblowers to blow the whistle on what they perceive to be an illegal DEI policy, it could actually create some risk for not only civil liability, but also criminal liability. David, do you want to handle the next question?
Sure, thank you. That was a good explanation of something that has kept us up at night for the last few weeks. As a team, we talk on a regular basis about what's going on and how to best position our clients. Hopefully, this information has been instructive. So I'm going to shift gears and focus on what are some of the illegal acts that the DOJ will focus on. But let me preface this by talking a bit about how the DOJ or a state attorney general is going to find out about an illegal practice. One thing is they can look at a website. And if a website is containing information about a DEI initiative or something along those lines, that could be a red flag right then and there. So it might not be a bad idea to take a moment to look at your website. And then the second is whatever paperwork that you've got in your employee manual or handbook about your trainings or your initiatives is another thing that you may want to look closely at. But the focus is on things such as a DEI training, programs that reference unconscious bias, cultural sensitivity, inclusive leadership, a race-based employee resources or support groups, a gender-based mentoring and promotion process, race-based fellowships run by third parties, race or sex-based preferences. And that goes back to that students from fair admissions versus Harvard that I talked about a few minutes ago, and reverse discrimination as a violation of Title VII. And, those are the types of programs that may be the focus for the Department of Justice or a state attorney general. But I hope you don't overreact. You've got to react. You've got to do something. I just hope you don't overreact and do something that can cause a lot more harm than good. And I know in a few minutes, we'll be talking about some of the risk tolerance, that employers face at this time. But I think what you can do is take a hard look at what your policies are now with respect to if you've got a DEI policy, if you've got harassment prevention training, if you're trying to create a better atmosphere for employees to work in. Don't give up. Don't throw in the towel. Take a few minutes, talk with someone who's either a consultant or a firm that can help you to modify your programs and what you're doing so that you can have a great place to work, that you can hire the best and brightest people to work for you. And, getting back to the one word the administration has used, which is a good word, meritocracy. But don't give up. Don't throw in the towel. Just take a bit of time to shift your position. Catherine, can you hit the next question, please?
Absolutely. Those are some excellent points that you just made, David. In fact, I may reiterate just a few of them in answering this upcoming question. This next question is, given the legal uncertainty of many of these initiatives and the enforcement of the same, what should companies do to protect themselves now? So David did touch upon a few of them. I'll try to not be terribly repetitive. But I do have to say this is a great and very relevant question. I think everybody is wondering right now, what can we do to protect ourselves? And first and foremost, I would say to proceed with caution and to analyze several factors. There is the matter of risk tolerance. How dependent are you on federal funding? Are you a likely target? David had discussed a little while ago what kind of organizations are likely to be targeted and what types of programs and policies would be targeted. And these are all considerations that you'll need to weigh. Another consideration is how to retain and attract top talent. It's still important from a business perspective to attract and to retain the very highest caliber of worker. And by focusing your recruitment efforts on skills-based, knowledge-based, and merit-based opportunity, rather than the applicants belonging to a certain race or sex, that is a way that you can protect yourself. Making sure that all are treated equally and documenting those decisions were merit-based and color, race, and sex blind is another way that companies can protect themselves now. I did want to mention that opening preferential programs like Black employee resource groups, for example, to everyone may not pass muster because the focus will be on the underlying intent of the program itself, as well as past practices and past statements would all be relevant and would all come up in a federal agency investigation. I think that a good way for private sector employers to deal with the increased scrutiny over legal or illegal DEI programs is to remember that DEI is not about exclusion. If a DEI initiative excludes people from a benefit based on their race or based on their gender, that is a heightened risk right now. Programs cannot confer advantages based on membership in a certain group. But if the initiative is about ensuring that all, regardless of race or gender, are aware of opportunities and benefits, that is generally permissible. And perhaps I should have started off with the reminder that companies are still legally required to honor their obligations under Title VII, under the ADA, and ADEA. Our legal precedent, our laws, our case law, these are all still the law, and it's not impacted by or rescinded by these executive orders. So those are just a few kind of brainstormed points as to how, even though we are in a very uncertain legal time right now, those are a few ways in which companies can work on protecting themselves in light of these recent executive orders. Denise, would you like to take a stab at the next question?
So Catherine, I think I might be jumping in.
Oh, forgive me. Yes, whoever would like to address the next one, please be my
Okay.
guest.
I think that the next question is where do we stand on the no taxes on tips proposal? So this has to do with some of the comments that were made. There's no executive order per se on this, but just it's been raised several times in the context of the election, whether tip income will be exempt from individual income taxes and payroll taxes. So this is a very popular proposal. I think some of the pros of this proposal were that it would incentivize the service worker industry, which, you know, during COVID was hit a bit hard. And it's very popular that, you know, tipped workers wouldn't have to declare their tipped earnings and wouldn't have to pay federal income taxes on their tips. However, a lot of concerns have been raised by several sources, you know, and some of those include that the proposal could undermine efforts to raise the minimum wage. And it would certainly reduce pressure on employers to raise base wages, because it would just be easier to keep them low and let their workers get tipped income, which wouldn't be taxed. One of the things employers should be careful about, though, in thinking about this proposal, is that it could also blur the lines between who's considered an employee versus an independent contractor. You know, if workers are now more easily classified as independent contractors because there are no payroll taxes for them, you know, the tax burden for these individuals could actually go up if they're now subject to self-employment taxes. And also to think through too, how this proposal could impact the business, where employers may pass costs on to consumers by pressuring them to tip more if their workforce has a very low base wage and depends solely on tips, which might cause passing these types of costs on to consumers. And then there's some practical consequences, including concerns raised about a loss in tax revenue, which is generated from tip income. And one source estimated this cost to be around $200 billion over the next 10 years, which is not insignificant. And it could also lead to potential abuse. For example, highly compensated professionals may want to shift their compensation structure to a tax-free tipping model. So clearly, if this proposal gets traction and moves forward, it's going to need some limits on how it would be imposed, you know, limits on the amount of capped deduction, for example, or limiting the first 20 or 25,000 in income from tips would, you know, be excluded from taxation or things along those lines. I'm not sure, we might be coming up on time here, but there was one other question having to do, but then I'm going to just dive right into having to do with the impact of the executive order on eradicating anti-Christian bias, and what this order, what impact it has on employers and employees. So again, this executive order, unlike the others, does not have language that suggests an immediate enforcement of these policies. Rather, this order talks about a task force being formed to basically identify what is described as anti-Christian conduct. The order doesn't specifically define what that is, but there's some hints in the text of the order that it applies to quote, anti-Christian governmental or private action. The order references, for example, governmental action in prosecuting pro-life protesters. It also talks about governmental policies or practices that are, quote, anti-Christian, but it doesn't describe what those are. It references, quote, anti-Christian conduct at college campuses. And it also references, quote, radical transgender ideology, close quote, in the workplace that is directly contrary to Christian faith. And it also talks about Health and Human Services refusing to allow Christians to adopt or foster children if they do not agree with certain beliefs on sexual orientation or gender identity. So the executive order is aimed at identifying, oh, and one other thing I forgot, it also talks about vandalism and hostility and violence against Christian churches and places of worship. So again, the executive order is really, it talks about a task force to review and identify this type of conduct in the government and to suggest ways to remedy it. And it raises a lot of questions. There's really not enough information currently to answer all the issues that come up with this particular executive order. But, you know, there are issues, obviously. For example, you know, in the workplace, can employers decorate their workplaces with religious or holiday symbols? Can employees put up flags on their desks or on the walls in their office, or wear certain religious symbols on their t-shirts or what have you? And it also raises questions about bathrooms and pronouns. And these are issues that we're going to have to keep in the forefront. And, you know, our firm will certainly be monitoring this for updates and guidance on really what employers' obligations are to comply with this executive order. So with that, I'm going to turn it back over to David.
Okay, thank you very much. I think I have the last question that we wanted to address, and this question was, what is the impact of the executive orders on the workplace? And that was a really interesting question because we remember a couple of years ago when we had the Great Resignation. Not at all sure why people called it great, but that's what they called it. And there were studies done on why people left their jobs. And, you know, one of them was the values. They wanted to work somewhere where they were proud of the place they worked. They embraced, many of them, millions of them, embraced places that had things like, you know, harassment prevention training, DEI initiatives. That's the kinds of places they wanted to work. So when I mentioned a few minutes ago, be careful not to overreact. When you figure out what you're going to do moving forward, a couple of suggestions. One is get the pulse of your employees. You know, what can you do to be consistent with the law, but and I think Catherine mentioned earlier, attract and retain the best talent. So take some time to consider that. It may be appropriate to do some surveys of your employees, informal polling of your employees. Take the time to figure it out and blend some best practices with being compliant. Thank you again for that question and all the other questions that were submitted. Catherine, I'm going to turn it over to you.
Great, thank you, David. That brings us to our very last slide here. We just wanted to take an opportunity to thank you again so much for joining us today. I know that we went through an awful lot of material, so please don't hesitate to reach out to us if you have any further questions or if you would like help in auditing your internal policies for compliance. Our phone numbers and our emails are listed on the bottom of this slide. You'll note that our emails are our first initial and our last name @wagnerlawgroup.com. And just remember, we are here to help. I'd like to sign off with just one quick last tip, and that is to please stay current on what's coming out of Washington, and don't be afraid to ask questions. All right, well, thanks again.